Hi, it's Mike DelSignore, and I want to discuss what happens if you're charged with open and gross lewdness in Massachusetts. I'm a criminal defense lawyer in Massachusetts. I've handled this charge for many people, and it can be the type of charge that can be debilitating, that could potentially cost you your job, could cause public embarrassment. So with open and gross lewdness is sort of criminal or sexual conduct that occurs in public. Examples of this would be someone who's engaging in sexual gratification, so to speak, in their car, and the public can see it. So there's different types of ways this charge can come about. I think it's pretty clear the type of behavior that this conduct prohibits. So in this video, I want to talk about how you can get these cases resolved. So there's two types of laws that punish this type of conduct. First, you have your open and gross lewdness. That is a felony offense, and that could result in sex offender registration if you're on your second offense. So if it's only your first offense, it's not going to require registration, but if you have a second conviction, it would. There's also indecent exposure. Now that's the type of thing that will sometimes be charged when maybe you go into the bathroom on the side of the road, or it's generally a lesser charge, it's a misdemeanor offense, and it's something that often, if you charge it open gross, you want to try to have it amended down to indecent exposure. Indecent exposure never carries sex offender registration requirements. It's not a sex offense. So it's a better way to resolve the case. So what are some of the ways we want to resolve a case like open and gross or indecent exposure? We first want to try to get some treatment, some help for you, so that we can argue to the DA that maybe dismiss the case, maybe give some kind of pretrial probation. Now, this isn't inconsistent with you asserting your innocence, that you're not guilty. You can do this at the same time. There's some allegations that led to the charge. We can address them and try to get the charge dismissed. We don't have to do that. It's sometimes people don't want to do that, but if in a lot of cases, most of my clients want to do something proactive. Most of them say, well, what can I do to help the situation? What can I do to make this case go away? And that's the best thing you can do, is proactively try to get help. And it applies regardless of your charge with open and gross. I recommend that if someone's charged with OUI, if you're charged with a drug crime, or if you're charged with a domestic, always doing something proactive is a way to lessen the potential penalty, and in some ways can result in the entire case being resolved without an admission, which is the key. So we've had magistrate hearings and cases in court where, because of someone's proactive steps, the cases have been dismissed. Now, let's say that's not an option in this case, then we can fight the charge, take it to trial. We can contest whether the government can meet the elements of the offense. Was this really open? Was it in public? Can they identify you as the person that some victim is claiming they were exposed, or the victim of this conduct? So those are the different types of defenses. Your first court date on this type of case is your arraignment date. You'll enter a not guilty plea. You'll get another court date. Now, in many cases, no one's at the arraignment, but there could be some media at the arraignment. There could be some public interest in a type of case like this. Make sure you don't speak to the media. Never speak to the media when you're charged with a criminal offense. That applies really across the board, regardless of what type of criminal offense you are charged with. After that, you'll get a pretrial date, and then it's at that time the cases take some time in the court system. As we work it through the court system, you'll continue to take some proactive steps. We'll put basically a package together and see if we can get the case resolved on our terms. Sometimes DAs will say, well, no, this is the offer. We want a guilty. We want a continuance without a finding on this. And then we either accept that or take it to trial. Now, continuance without a finding is not a conviction, so it is potentially a useful way to resolve a charge of open and gross behavior. But your first option, though, is you want to see if you can get it amended down. So they charge, you violate one statute. We want to see if we can have the charge reduced to a different statute where the penalties are less. If you have questions on this, feel free to contact me. My name's Michael DelSignore. Help people with this with charges of sex-related offenses, open and gross lewdness, and all criminal offenses throughout Massachusetts. Call me anytime, 781-686-5924. I'm here to help.